We're going to call to order the special commission meeting for the purpose of reviewing the body-worn camera COMAR update. And we will do a roll call, even though we do have a quorum. Everyone knows who I am, Carolyn Scruggs, Secretary, Department of Public Safety. And let's just go around the room. Ms. Ebb, you want to go?
Good afternoon. I'm Nicole Ebb, from the County Department of Corrections, President of MCJA.
Anthony?
Good afternoon, Anthony Gaskins, Chief of Staff at the DPSES.
Betsy?
Good afternoon, Betsy Fox Tolentino, Secretary, DJS.
Dr. O'Brien?
Good afternoon, Dr. Beverly O'Brien, representing Dr. Anthony Jenkins, President of Coppin State University.
Chris? I thought I saw you weren't going to make it. Go ahead, Chris Klein.
Christopher Klein, Superintendent, Anne Arundel County, Vice Chair, PCTC, President, MCAA. Present.
Mike Dole?
Good afternoon, Michael Doyle, Deputy Principal Counsel, Office of the Attorney General.
Ms. Connors?
Sharon Connors, Assistant Attorney General, DPSES.
Matt, who else did I see? Did I see Matthew? I'm trying to change my screen.
Yes, ma'am. Matthew Fonseca, Acting Deputy Secretary, Residential Services for the Department of Juvenile Services.
Reva?
Yes, Reva Chopra, Assistant Attorney General, DPSES.
Officer Okanoran?
Yeah, good afternoon. This is Sergeant Okanoran, Correctional Officer of the state.
Who did I miss, guys? Apologies, you know we're on the screen.
Captain Barnett.
Captain Hayana Barnett, Department of Public Safety, Regional Representative.
I apologize, Captain Barnett.
No problem.
And the team at PCTC that's in the room, you want to introduce yourselves?
Good afternoon. I'm Matthew Milady. I'm the Deputy Director of the Correctional Training Commission.
Chaka Cross, PCTC.
Deidre Carrier, Westby, Executive Director, Correctional Training Commission.
Lashane Nicholson, Deputy Director of Administration for DPB. Kate Gosser, Public Safety Education and Training Center.
Gary Gardner, Director of Policy, PCTC.
Kevin Durling, PCTC Policy.
Great. Hopefully you all have had an opportunity to review the Title 12 draft that was sent to us. I did review. I had originally made a update on 0.07, but then I realized that because I wanted to say that they were not limited to that area, but I realized that it also in section C already include additional qualifying events. But are there concerns that we need to bring up? Anything that we need to focus on, Dr. O'Brien? You're on mute, Dr. O'Brien.
Sorry, I just had one editorial comment, and that is under the definition section where you have operational definitions for this proposal. All of them give a definition, an operational definition, except 10 and 11, which refer you back to the original. But I think in the document, it should state, as it does in everything else, because the reader would then have to have the access to the other document to understand the operational definition for incarcerated individual and for the Maryland Public Information Act.
Okay, that's a great update. I agree. And we can take that definitely directly from the annotated code, what the definition is there. So she is referring to 0.02 definitions, number 10 and 11. We want to put the full definition of incarcerated individual and of Maryland Public Information Act. We don't want to refer them back to the annotated code that outlines what that definition is.
Right.
Madam Secretary.
Yes.
As far as COMAR goes, normally that is the process. If the definition is exactly as it is in the code,
that's the reference that is used in COMAR. If there's a deviation from it, then the entire thing would be written out. But the reference that we use for consistency purposes, the COMAR style manual has you indicate what section and code that is. So that's.
I'm familiar with that, but I think more and more people are looking at what we do. And this could be a challenge for them to have to go back and find out what is a true definition of an incarcerated individual, or what does the Maryland PIA actually entail. Others that don't see the need or see the need for us to update this. The attorneys have any other comments related to this update? Mike?
I think it is a matter of COMAR style. I don't have I mean, it's not a legal issue per se. I don't have an issue with defining incarcerated individual. Public Information Act may be a little bit trickier because the Public Information Act is the entire statute. So it may be hard in a phrase or a sentence to define it. We could add a brief description of it if that was necessary, though.
Or is it possible to put in a link so that they don't have to go look for it?
Hyperlink.
A hyperlink so that they don't have to go look for the document?
No, because when this goes into the Division of State Documents, they don't have hyperlinks set up that way.
So I guess we need to make a decision as to whether or not we are going to leave as commonly notated, or whether or not we feel as though there is a need to expand. I think, like Mike said, it's very easy to expand what incarcerated individual is. That definition is pretty short and solid. The Maryland Public Information Act, it goes through in detail a lot of information. It will probably take up another page or so if we added that. But I think some type of way we have to ensure that when people read this, they understand and they know. Because the more clarity we provide individuals, the better they're going to understand and the less questions they're going to ask us. So I'm open for suggestions right now as to how we move forward. Don't everybody speak now. Go ahead, Chris.
I have my hand up for another point, but I believe, as noted, based on the stylistic guide, I would say keep it the same. I understand there are challenges to going and looking at other sources to figure out what you're trying to do. But I think for those specific terms, I think following the stylistic recommendations would be my choice.
So all that agree with following the style. Can you just put your hand, raise your hand on your screen so we'll know? All right. Let's see, 1, 2, 3, 4. Are the others saying that we need definitions? And if so, please tell me.
I think we need something. If it's open to the community to be reading it and they don't necessarily know what the professionals know, I see that as a problem.
Okay. Matt, I'm going to turn to you. How do we usually move forward with something like this? Because we have a few people that we understand it's the style, but others that are deeming that it definitely needs to be outlined a little better for clarifications and suggestions.
Can it be put in as an appendix? I mean, is there an abbreviated form that can be put in as a written appendix at the back of the document?
Ordinarily, that's not the style, and the folks that they make the final determinations in Comar. I mean, the commission can make that change. It's not likely to survive DSD review. So just to have a heads up, it's because there are so many Comar regulations that follow this style, and that's what they actually put in the style manual, that even if the commission does expand on these definitions, it's likely to not appear that way in the final draft that's actually published.
Is there any acceptable manner that Comar definitely that's ordinarily used in this kind of circumstance, or they just leave it to the individuals?
Where there is a definition that already appears under the authority of an article or Comar, this is the style that they ordinarily go with, and this is what they put in the style manual. So that's why we drafted it that way, to be consistent with what they ordinarily approve.
And Madam Chair, Secretary Scruggs, if I may, thanks.
Sure.
I think also, you know, this is the Comar piece, but the agencies or correctional units that will be implementing will probably have their own policies and procedures that will have more detailed information as it relates to the definitions that their frontline staff would need to be able to understand to operate or to carry out the policy or procedure. So, I mean, there's going to be other places I'm sure that the units will expand on this information to make it clear for community inmates as well as staff.
Yeah, that's a great point, Betsy. When the individual institutions create their policy, it will be outlined in their policy in more detail.
Yep, and if I could add to that, just if they're using the Power DMS platform to develop those policies and procedures, you can put in your own links, which we have done in Anne Arundel County, either a reference or a hyperlink into that policy. So then there would be a direct contact for the people reviewing it internally, though I understand Beverly's comment about for external, that's a little bit challenging.
So Dr. O'Brien, are you good with the fact that we can, in our additional policies that will come from out of this, add that link and expand upon those definitions there?
I think that's fine.
Okay. Okay. Chris, I think you had another one you wanted to bring up.
I did. I was actually looking at 0.07 on qualifying events, and I just wanted to confirm, I don't recall the discussion 100%, but the mandatory recording for cell searches, the way I read that now is cell searches are mandatory, clothes frisk searches are mandatory, searches of visitors and incarcerated individuals are mandatory, and then any other facility search in accordance with the correctional unit's policy. Or is that well, I mean, am I reading that correct? That every cell search, we have to record every cell search that we do?
I'm not reading it that way. I'm reading it that is a qualifying event, which means that you can execute the use of body-worn cameras with that.
See, but I read it as mandatory. It says qualifying events mandatory, so we don't have the option to not record cell searches. And so
So is it the use of the word mandatory recording, and we need to take mandatory from out of there?
Well, the law requires that we identify under, I don't know what number, mandatory events. So I'm assuming that's what that section is, what we're trying to accomplish. But when I look at what's in there, I mean, I agree, critical incidents, use of force situations, cell searches, I think we start to get into a lot of recording, which then follows, you know, are people writing reports on every recording? Is that going to every supervisor? I just don't know. Like, I like the language in an agency may include other events, and then we could do like a such as cell searches, visitor searching, things of that. But I just don't know if it becomes mandatory as part of this regulation, then it'll be mandatory for everybody in every situation.
So number 4 should be, what you're recommending is number 4 is an extension of C. That may include those types.
Yes, that's what I would recommend, but I don't.
And it is because of the high volume of what we do in those areas.
Absolutely. And that we're talking about one of the sort of challenges with body worn camera and this type of technology is how much information are we holding and saving? And I just don't know that seems like a lot for our business.
Anyone? Go ahead.
But does that, so as I'm reading it, it says in accordance with the correctional unit's policy. So would that cover it there that according to that facility's policy, when the cell search is being recorded?
I think the way that's written grammatically, though, I think that's an addition. Right? So the one off of 4 and facility searches, so that's anything else. But the first 3 are definitely mandatory. First 3 or 4.
Okay, I think we might have a difference of interpretation, so we probably do need to clarify it for the masses. If we're not agreeing that it's saying anything, then they're definitely going to interpret it a different way.
So can we all agree that numbers 1, 2, 3, and 5 are mandatory? We're good with that. Anybody
Yes.
not?
Yeah.
Okay. Number 4, it may just be a play on words in the way that we word it. Does number 4 become a subsection under C to make it safer? Or is there proposed verbiage to change the way number 4 is? The concern is that we do an abundance of cell searches during the course of the day, the week, whatever, as well as searches every time an employee comes in the building, leaves the building, visitors coming in and out. So this makes it very, very broad.
And then I think I had a question with the word mandatory being there. To leave it as qualifying because if we lock it into mandatory, are we going to have enough cameras to cover all of these areas in all our facilities? So let's say something happened and it doesn't get recorded because we don't have the cameras in that area. Are we in violation because it was a mandatory recording?
I agree. So do we move it to an agency may include other events as qualifying events as long as they are not prohibited under regulation 0.08 of this chapter, and then say these include but are not limited to cell searches, clothing.
Yeah, I like that language.
I like that.
I like that as well. We gotta make a motion.
One other possibility just to consider would be to move the cell searches under discretionary use of VWCs in regulation 09. It would potentially be A3. And then if an agency wanted to make it mandatory, the agency could do that, but it wouldn't be required of every agency.
I could live with that as well. I didn't think about that.
I agree with moving it there.
And that would become number 3. Is that what you're saying, Matt?
Yes.
Okay. Yeah, I'm good with that as well. That's even better. Anyone opposed to moving it to number 3? Okay. Ms. Barnett, you still have your hand up?
I'm sorry.
Okay. Someone else, any other changes or concerns?
So do we leave number 7 as mandatory recordings, or do we just name it qualifying events?
It's still mandatory recordings.
Which that matches the requirement under the law to identify mandatory. So I agree with that.
Okay.
Mm-hmm. Okay, team at PCTC, is there anything else that we need to do related to this?
Yes, just one other item, and that's in the definition section as well. Initially, and we forgot to take it out after our last meeting, number 9, evidentiary video. That was only impacted in one area. of the regulation. And Mr. Doyle recommended that we take out the word evidentiary and just left it with body worn camera video. And that's under the access and storage section. So we just made it video instead of evidentiary. So that just means all video.
Okay.
There's no need any longer.
Any concerns with moving the word evidentiary from number 9 and just labeling it video? Just clean up. Go ahead, Chris.
Just clarify, you saying the word evidentiary only came up one time?
Evidentiary video.
Okay.
So actually the whole definition could be removed, the entire definition.
Okay.
Because we no longer reference that term anymore.
Okay. I agree with that if there's the term's not referenced.
So there is no number 9.
Right. That should, from what we're being told, they no longer reference that term, so we can totally remove it. And that's guidance from legal.
That's correct. Yeah.
Okay. Anyone disagree? Okay. Anything else? So I think what we've decided is, one, we're going to remove number 9 because it's no longer a term that's referenced. We are going to leave 10 and 11 as is because it is the COMAR practice and style. And we are going to move number 4 under 0.07 and make that number 3 under 0.09 so that it becomes discretionary. Those are 3 changes that I had. Did I miss something?
I think that's it. I think probably a motion to accept all those changes would be in order.
Okay.
Long
Can I
as
get
they're-
All right. Can I get a motion to accept the changes?
Motion.
Second?
Second.
Okay.
Okay. Changes are approved. And this was easy for us.
Well, you need to go ahead and vote.
Okay. You need an out loud vote from everybody when you go around.
Yeah, I'll do the roll call. Secretary Tolentino,
Yes.
Chief Gaskins,
Yes.
Deputy Secretary Fonseca,
Yes.
Superintendent Klein,
Yes.
Ms. Ebb,
Yes.
Ms. Connors,
Yes.
Dr. O'Brien,
Yes.
Sergeant Okanoran,
Yes.
Captain Barnett,
Yes.
and the motion carries. The motion carries, Secretary Scruggs.
Okay. Motion is approved. Those are the updates that we'll make, and then the team will submit the updates to the regulation. Do we have any other business that we needed to take care of?
That's it.
That's it. Okay. We are going, say it again.
A motion to adjourn.
Yeah, we're gonna, I'm gonna request a motion to adjourn this session.
So moved.
Motion.
Second.
Second.
Second, Norland.
All right. Thank you, everyone. I'll give you some of your afternoon back.
All right.
Have a great day.
Thank you.
All right, bye-bye.
Thank you very much.
Bye.
Thank you.